we face a critical juncture in the ongoing fight for fundamental constitutional liberties. Today, the conversation is not merely about legislative proposals or abstract legal theories, but about individual freedom, personal redemption, and the potential for a lifetime of punitive measures to unjustly strip an American citizen of their most basic rights. The stakes are profoundly high, touching upon questions of societal forgiveness, the purpose of our justice system, and the very definition of a law-abiding citizen. This is not a hypothetical debate. It is a live legal battle with tangible consequences for millions of Americans, and it demands our immediate and serious attention. The core issue unfolding before us centers on the complex and often contradictory legal framework surrounding the restoration of firearms rights for individuals with past felony convictions. While the collective voice of the American people often struggles to gain traction in the halls of power, sometimes a prominent figure can illuminate a pathway to change. In this instance, a well-known country music artist, Jelly Roll, has taken a courageous stand, bringing an intensely personal and often overlooked dimension to the Second Amendment debate. His public struggle to regain his right to own a firearm has injected a powerful human element into the cold calculus of legal statutes and historical precedents. Jelly Roll, a highly successful musician, has openly discussed his deeply troubled past, a history marked by more than 40 arrests and serious convictions, including aggravated robbery and drug charges, for which he was tried as an adult at the age of 16. Now, years later, a rehabilitated and contributing member of society, he finds himself in a legal quandary. Despite seeking a pardon from the governor of Tennessee, state law, specifically pertaining to violent offenders, maintains a permanent lifetime ban on firearms possession. This absolute prohibition, he argues, denies him not only the ability to participate in activities like hunting, which he credits with aiding his mental and physical well-being, but also forces him to incur immense personal security costs, reportedly over $1 million annually, simply because he cannot exercise the fundamental right to self-defense. His plea, articulated on a prominent podcast, resonates far beyond his celebrity status. There must be a clear and accessible path to redemption, a mechanism by which individuals who have genuinely turned their lives around can reclaim their constitutional rights, irrespective of their past mistakes or financial standing. This situation throws into sharp relief the fundamental legal and policy trap inherent in our current system. Federally, Title 18 United States Code, Section 922, G1, broadly prohibits any person who has been convicted in any court of a crime punishable by imprisonment for a term exceeding 1 year from possessing a firearm. This federal prohibition extends to nearly all felony convictions, irrespective of their nature, violent or nonviolent, or the passage of time. States, however, maintain their own additional layers of restrictions, some mirroring the federal ban, others, like Tennessee, adding even more stringent lifetime prohibitions for certain categories of offenses. The historical underpinnings of felon disarmament are complex, rooted in concepts of civil death from English common law, where individuals convicted of felonies were stripped of many, if not all, of their civil rights, including the right to vote, hold office, and bear arms. This was often tied to the idea that such individuals lacked civic virtue and were no longer considered full members of the political community. However, the application of such historical concepts in modern America, particularly after the ratification of the 14th Amendment and the evolving understanding of individual rights, presents significant legal challenges. The Supreme Court's rulings in District of Columbia v. Heller in 2008 and McDonald v. City of Chicago in 2010 affirmed the Second Amendment as an individual right, applicable to the states. While these landmark decisions acknowledge that the right is not unlimited and certain categories of individuals, such as felons and the mentally ill, could be disarmed, they did not definitively settle the constitutionality of absolute and permanent bans for all felons, especially those deemed rehabilitated or those convicted of nonviolent offenses. The pivotal case of New York State Rifle and Pistol Association, Inconsistency v. Bruen, decided in 2022, introduced a new and demanding standard for Second Amendment challenges. The Bruen decision requires the government to demonstrate that any firearm regulation is consistent with the nation's historical tradition of firearm regulation. This text and historical tradition test provides a potential avenue for challenging blanket felon bans. Legal scholars and civil rights advocates are now rigorously examining whether a historical tradition truly supports permanently disarming all felons, regardless of the nature of their crime or their subsequent rehabilitation. While historical analogues exist for disarming certain unvirtuous citizens, the scope and permanence of modern felon bans may struggle to meet Bruen's strict standard, especially concerning nonviolent offenses or after demonstrably long periods of law-abiding citizenship. State laws, adding to this labyrinth, vary widely. Some states offer robust mechanisms for rights restoration, including pardons, expungements, or certificates of rehabilitation, which can, under specific conditions, restore an individual's right to possess firearms. Other states, however, impose far stricter limitations, with some maintaining lifetime bans for all felonies, or, like Tennessee, for specific violent offenses, even after a gubernatorial pardon has been granted for other purposes. This patchwork of laws creates an inconsistent and often arbitrary system, where an individual's fundamental rights can depend less on their current conduct and more on the state in which their past conviction occurred. The specific challenge faced by Jelly Roll in Tennessee perfectly illustrates this policy trap. Despite a potential pardon from the governor, the state's lifetime ban for violent offenders remains an insurmountable barrier. This distinction between a pardon's ability to forgive the offense and its inability to restore certain fundamental rights highlights a critical legal disconnect. A pardon signifies official forgiveness and restores many civil liberties, yet the right to bear arms remains elusive for a specific category of offense, creating a permanent second-class citizenship status for those who have paid their debt to society and demonstrably reformed their lives. The implications for individuals are severe and carry immense personal liability and risk. For any person previously convicted of a felony, even one from decades past, the mere possession of a firearm, whether it is an antique handed down through generations, a hunting rifle, or a handgun for self-defense, constitutes a federal felony offense. A violation of Title 18 United States Code, Section 922, G. 1, can lead to imprisonment for up to 10 years, a fine of up to $250,000, and further irreparable damage to one's life. State laws carry similar, often equally harsh penalties. The enforcement of these laws by federal agencies like the ATF and the DOJ is stringent, leaving little room for error or misunderstanding. The Supreme Court's decision in Rehafe v. United States in 2019 clarified that for a conviction under Section 922, G. 1, the government must prove that the defendant knew they possessed a firearm and also knew they belonged to the category of persons prohibited from possessing firearms. While this adds a layer of protection, it does not excuse ignorance of the law itself. A rehabilitated individual who genuinely believes their rights have been restored, or who simply misunderstands the complex legal landscape, could still face severe felony charges if they are found to be in possession of a firearm. The burden of understanding the precise nuances of federal and state firearms law falls squarely on the individual, a burden that can be incredibly heavy and unforgiving. Beyond the threat of incarceration and financial ruin, individuals with felony convictions often face a broader loss of civil rights. In many jurisdictions, they are disenfranchised, unable to vote, serve on juries, or hold public office. While many states have moved to restore voting rights after release from incarceration or completion of parole, the right to bear arms often lags behind, seen as a distinct and more sensitive privilege. This creates a moral and practical dilemma. A person who has fully paid their debt, contributed positively to their community, held steady employment, and raised a family, remains perpetually marked, unable to protect themselves or their loved ones in the same manner as other law-abiding citizens. This perpetual second-class status undermines the very notion of rehabilitation and reintegration into society. The bureaucratic nightmare and financial implications of attempting to regain firearms rights are equally daunting. The pathways to restoration, pardons, expungements, certificates of rehabilitation, are not easily traversed. They often involve lengthy, expensive, and complex legal processes. Engaging legal counsel to navigate state and federal requirements can cost tens of thousands of dollars, a sum far out of reach for the average citizen, let alone someone still rebuilding their life after a conviction. The process can take years, involving extensive paperwork, background checks, interviews, and often a political decision from a governor or clemency board. This creates a deeply unequal system. As Jelly Roll himself pointed out, only the wealthy or well-connected might realistically have the resources and influence to pursue these avenues, leaving the vast majority of rehabilitated individuals without a viable path to reclaiming their fundamental rights. This disparity fundamentally contradicts the principle of equal justice under the law. Furthermore, the hidden costs extend beyond legal fees. As Jelly Roll's experience vividly illustrates, the inability to legally carry a firearm for self-defense forces individuals, particularly those in the public eye, to rely on expensive private security details. This financial burden, reaching millions of dollars annually for some, highlights the tangible economic consequences of firearms prohibition, far removed from mere ideological debate. The psychological burden of perpetual second-class citizenship, the constant fear of inadvertent violation, and the inability to fully participate in community life or recreational activities like hunting, further compounds the injustice. This individual struggle, amplified by a celebrity's platform, transcends personal narrative and points to a broader, more insidious implication: the ongoing erosion of fundamental rights. If the government can indefinitely strip a person of a core constitutional right based on a past mistake, even after that person has demonstrably reformed and contributed to society, what precedent does that set for other rights and other categories of citizens? The argument often made for permanent felon disarmament centers on public safety, and the idea that anyone with a felony conviction, regardless of its nature or how long ago it occurred, poses an unacceptable risk. However, this argument often fails to differentiate between a violent career criminal and a reformed individual who committed a non-violent offense decades earlier. The concept of a blanket ban without a meaningful and accessible path to restoration reflects a tough-on-crime posture that prioritizes perpetual punishment over the potential for human redemption. This approach can be politically expedient, but it often sacrifices justice and individual liberty. Federal agencies like the DOJ and the ATF, tasked with enforcing these broad prohibitions, operate within the current legal framework, but their interpretations and enforcement practices often expand the scope of these laws, making it increasingly difficult for anyone with a past record to navigate the system without fear of severe penalties. The Bruen decision offers a ray of hope for those seeking to challenge these permanent bans. By mandating a historical tradition test, courts will now be compelled to look beyond modern policy preferences and examine whether the historical record truly supports the absolute and permanent disarmament of all felons, including those who are no longer a threat. This is a profound shift that could force states to rethink their lifetime bans and create more nuanced systems that differentiate between violent and nonviolent offenses, and that acknowledge the possibility of rehabilitation. The outcome of cases like Jelly Rolls, and the broader public and legal discourse they ignite, will be crucial in shaping the future of Second Amendment jurisprudence and the rights of millions of Americans. It forces us to confront uncomfortable questions about who we deem worthy of full citizenship, and whether our justice system truly believes in the transformative power of a second chance. This is precisely why we must remain vigilant. This debate is not merely about a celebrity or a specific statute. It is about the fundamental principles of liberty, justice, and the Second Amendment. The very foundation of what it means to be a law-abiding citizen is at stake. The idea that a past mistake, no matter how distant or non-violent, could permanently brand an individual as unworthy of a constitutional right runs counter to the spirit of American justice and the concept of redemption. We must advocate for meaningful pathways to rights restoration that are fair, transparent, and accessible to all rehabilitated individuals, not just those with the means or connections to navigate a complex bureaucratic maze. This requires engaging with our state legislators, challenging outdated laws, and ensuring that any legal framework differentiates between demonstrably dangerous individuals and those who have genuinely reformed their lives. The Second Amendment declares that the right to keep and bear arms shall not be infringed. This protection must extend to all law-abiding citizens, including those who have served their time, paid their debt to society, and proven their commitment to living within the law. The fight for these rights, for the opportunity for redemption, and for a justice system that values rehabilitation is why we must tirelessly engage in the defense of the Second Amendment every single day. We must not allow arbitrary or overly broad prohibitions to erode the constitutional protections intended for all free Americans. Thanks for watching. See you in the next video.